we continue looking at this case, divorce case between Delsha Hyman Hall and Noel Hall. Now, maintenance for child of the family. Now remember, Mr. and Mrs. Hall were married, and Mrs. Hall lived in Mr. Hall's apartment for 4 months and 7 days, then left. And they left due to frequent quarrels over money. Mrs. Hall has a child for her ex-husband, which she carried into the household. She had applied for half the value of the apartment. She had applied for maintenance for herself, and she also applied for maintenance of her child, which she had with another man. All of this after 4 months and 7 days of marriage. Even though, of course, her husband said he moved out of the matrimonial bedroom after 3 months. And then she moved out of the apartment completely about 1 additional month later. Section 8 of the Maintenance Act provides that subject to subsection 2, every parent has an obligation to the extent that the parent is capable of doing so to maintain the parent's unmarried child who is a minor and who is in need of such maintenance by reason of physical or mental infirmity or disability. Now remember what the Maintenance Act says, Once the child is below 18 years old, that's a minor, so you have to maintain them. Now, if the child reaches 18 or above, if they are enrolled in a course of study at a tertiary institution, you have to maintain them up to age 23. But whatever age the child is, whether they pass 18, 23, in their 30s, if they have a medical condition that prevents them from earning, then you still have to maintain them. Now, for the purposes of this act, a person is the parent of a child if that person's name is entered as the parent of the child in the General Register of Births. So if you sign the birth certificate, you are a parent of the child. Or the person. The person is or was a party to a marriage, including a void marriage or cohabitation, and the child is a child of the marriage or cohabitation. Now this part in bold applies directly to this case. That the person is a party to a marriage or cohabitation and accept as one of the family a child of the other party to the marriage. That means if your spouse has a child for somebody else and you accept that child as a child of the family, then that child, you can be forced to maintain that child. Other provisions, of course, are that you accept the child, adopt the child. Well, Mr. Hall did not adopt this child, and the person had admitted paternity to a court and has made a declaration of paternity. Well, Mr. Hall is not the biological father of this child. All right. Fast forward to this section here. The court did not believe that sufficient evidence was led by Mrs. Hall to establish that her child was accepted as a child of the family by Mr. Hall. There was no evidence, for example, that the child was referred to by Mr. Hall as his daughter. Her surname was not changed. No evidence of the defendant assisting her with any homework or taking her to school, etc. So the thing is, if Mr. Hall had assisted the child with homework or took her to school and so on, then Mrs. Hall could have presented that as evidence and the court would consider it. The only relationship established was that the defendant, Mr. Hall, brought groceries and has paid for some extra classes, as said by the defendant, outside of groceries for the house, even the snacks for the relevant child, and anything outside of general groceries were provided by Mrs. Hall. The court also accepts Mr. Hall's evidence when he said that Mrs. Hall paid all educational expenses for her child and that he, Mr. Hall, never assumed responsibility for the child's care or upbringing, and he never gave any input to the child's affairs. The court also finds favor with Mrs. Batchelor's contention that the claimant had received an order of maintenance from the child's father and therefore has the opinion or the option to instigate the relevant process to recover any monies due and owing to her for maintenance of the child. Remember, Mrs. Batchelor is Mr. Hall's lawyer. It is unreasonable not to pursue the maintenance from the child's biological father, but to pursue it from against someone with whom she lived for less than 5 months and with whom she shared a bad relationship. Right? So the judge is saying here that the child's biological father is there. It would be unreasonable to say that the child's biological father should not support the child, but another man with whom the mother lived for 5 months should support the child. It would be unreasonable. There was no special relationship established between the child and the defendant. The lack of communication after the separation is quite indicative of the lack of bond and acceptance of the child by the defendant. Right? It's not like the child and Mr. Hall were communicating. Mr. Hall didn't visit the child after. There was no bond established. The defendant has not had any access to the child since the separation. They had no telephone contact. They had no relationship at all. And the court does not believe that the minor was treated by the defendant as a child of the family. The court therefore does not believe that the defendant should be asked to maintain her or to contribute to her maintenance. Alright, just before I finish this section, I have to say that that child would have learned a lot of very bad lessons. And just imagine the emotional, psychological damage to that child. Her mother moved her into a new man's house the child would have seen, very likely, would have seen and would have witnessed all the fights, loud arguments over money. Mr. Hall's mother had to move out after Mrs. Hall made allegations against her. And Mr. Hall had to move out of the matrimonial bedroom within 3 months. Was the child living with them? That would have happened. The child would have witnessed all of that. Was the child living with them in the apartment? It would be unreasonable. I believe that the child might have been living with them in the apartment. But if that is the case, then the child would have had to witness all of that. Very unfortunate. And even if the child was not living with them in the apartment, she would still have learned some very, very, very bad lessons in terms of what to expect when she grows up as an adult woman ready to form a family with a man. Very unfortunate.